that a case must take to end up before the court. The home of the International Court of Justice, as you see on the photo behind you, the Peace Palace, as it is called, is an imposing and opulent building in The Hague, built and maintained even today by money from the Andrew Carnegie and the Carnegie Foundation. The first stone was laid during the Second Hague Peace Conference in 1907, and the building itself was designed by a French architect with two towers, which you can see, one great and one small, marking the two courtrooms, which are the most important parts of the palace. Set apart from the main centre of The Hague, the Peace Palace is surrounded by a very large garden, which echoes the peace ideal of the building. In its design, plants with sharp thorns were avoided, and the ancient trees were allowed to remain and to shield the garden from busy city life. To get into the courtroom, one enters the palace precinct through the external security gates and walks up the long path through the tranquil gardens, up the marble staircase, through enormous bronze and steel doors, underneath a large window with the inscription Pax, and into a foyer that is filled with light. It is a walk that is inspiring and profound, as indeed is the work of the International Court of Justice itself. It is the principal judicial organ of the United Nations and acts as the World Court. Of course, the journey of the lawyers into the courtroom is by no means the beginning of the cases that serve before the International Court of Justice. Leading up to this moment are a number of hurdles which must be overcome, including questions of standing, jurisdiction, and the existence of a dispute, the who, the where, and the what of a case. In this address, I intend to take you on a tour through the gates of the International Court of Justice, describing first how the work of the court came to be, and then explaining how a case can proceed through the doors of the Peace Palace to serve before the ICJ. Following the First World War, the Covenant of the League of Nations gave the Council of the League responsibility for formulating plans for the establishment of a permanent court of international justice, which would be competent not only to hear and determine any dispute of an international character submitted to it by the parties, but also to give advisory opinions on any dispute or question referred to it by the Council or Assembly of the League of Nations. In December 1920, the Statute of the Permanent Court of International Justice was established, and the first incarnation of the World Court became a working reality. The outbreak of the Second World War in 1939 had serious consequences for the court, and in fact, for a period after that year, the court dealt with no judicial business at all, and no judges were elected. But in 1943, following the Moscow Conference, China, the then USSR, Russia, the United Kingdom, and the United States issued a joint declaration recognizing the necessity of establishing at the earliest practicable date a general international organization based on the principle of the sovereign equality of all peace-loving states and open to membership by all such states, large and small, for the maintenance of international peace and security. And so, out of this commitment, the United Nations and the International Court of Justice as we know it today was born. The ICJ itself was established in 1945 by the Charter of the United Nations. And out of the 6 principal organs of the UN, it is the only one that's not located in New York. The court is comprised of 15 permanent judges who are elected by the UN General Assembly and Security Council, and its official languages are English and French. The ICJ has jurisdiction in 2 broad types of cases. First, it gives non-binding advisory opinions on legal questions referred to it by organs of the United Nations or certain specialized agencies and affiliated agencies of the UN. In the second category of cases, the ICJ adjudicates legal disputes submitted to it by states in accordance with international law in contentious proceedings. Similarly to our South African legal system, contentious proceedings commence with a written phase, in which the parties file and exchange pleadings containing facts and law on which each party relies, and then an oral phase of public hearings at which agents and counsel address the court. Preliminary challenges to jurisdiction and standing will typically be separated out as points in limine for an earlier hearing. Following deliberation, a judgment is delivered, and this judgment is final and binding on the parties to the case. There is no appeal. In contentious cases, the key principle is that the court only has jurisdiction on the basis of consent. Jurisdiction is not compulsory and is in fact often challenged by a respondent before the ICJ as a preliminary objection, and it can be hotly contested. Article 36 of the court statute outlines the bases on which a case can be brought to the court. So first, the jurisdiction can be founded by a special agreement or compromis under Article 36, paragraph 1 of the statute, where both states parties to the proceedings jointly refer a dispute to the ICJ and consent to the ICJ's jurisdiction. Since there's no applicant and no respondent state, in these cases, in the reports of the ICJ, you'll see that instead of having a V between the parties, the law reports have a slash. So you'll see Benin/Niger. The other way for a case to be brought to the ICJ is through application proceedings, which involve a unilateral application by an applicant state or states against a respondent state. And at the end of the official title in these cases, the two parties are separated by the abbreviation V versus, so Nicaragua versus Colombia, South Africa versus Israel. What kinds of matters can be brought then? There are again two bases for the kinds of cases that can be brought to the ICJ. Firstly, the ICJ has jurisdiction over, I quote, matters specifically provided for in treaties and conventions in force. Many international treaties contain these compromissory clauses. The Genocide Convention is a good example. And it brings within the jurisdiction of the court disputes between contracting parties relating to its interpretation, application, and fulfillment. That is Article 9 of the Genocide Convention. However, there are loopholes here, as states may become a party to the convention, but may enter a reservation in relation to the jurisdictional clause of the particular treaty. So, for example, the United States is a party to the Genocide Convention, but has entered a reservation under Article 9, which means that it does not consent to the jurisdiction of the ICJ and could not be brought before the ICJ under the Genocide Convention. Secondly, the ICJ has jurisdiction over states that have made declarations that they accept the ICJ's jurisdiction as compulsory. These are known as optional clause delegations. Again, there may be reservations. So Australia accepts the compulsory ICJ jurisdiction, but with reservations, including around alternative dispute resolution and disputes pertaining to maritime zones or disputed areas. The United States of America had previously accepted the court's compulsory jurisdiction when it was created in 1946, but withdrew its acceptance following the court's judgment in 1984 that called on the United States to cease and to refrain from the unlawful use of force against the government of Nicaragua. In the Nicaragua versus US case, the majority of the court had ruled that the United States was in breach of its obligation under customary international law not to use force against another state and ordered the US to pay reparations, although it never did. Who then can bring an application before the ICJ, and against whom? Only states are eligible to appear before the court in contentious cases, not individuals, not organizations. And usually, only state parties with an interest in a particular dispute can institute proceedings. The pitfalls of failing to establish such interest are demonstrated starkly in the Southwest Africa case that Chris talked about earlier. Here, you'll recall, on the 4th of November 1960, Ethiopia and Liberia instituted proceedings against South Africa, alleging that South Africa was breaching international law in that it was practicing apartheid by distinguishing as to race, color, national or tribal origin in violation of international law in relation to what was then Southwest Africa. Although the initial bench had rejected a preliminary objection based on standing, at the merits stage, the question of standing was revisited. By the casting vote of the president, the votes having been equally divided, the court then found in 1966 that Ethiopia and Liberia could not be considered to having established any legal right or interest appertaining to them in the subject matter of their claims, and the court rejected the application. But in addition to interest-based standing, there is a category of international law violations that are considered so offensive to the international order that all states can be held to have a legal interest in their protection. These are obligations erga omnes. Cogent examples are those owed under the Genocide Convention and the Convention Against Torture. The prohibition of genocide and of torture are peremptory norms. Obligations of these conventions are erga omnes obligations owed to the international community as a whole. State parties to these conventions are obliged not only to desist from genocidal or tortuous acts, but also to prevent them. Within this category of erga omnes obligations, all states parties to the treaties in question have an automatic right of standing to bring a claim based on an alleged breach of the convention by another state party. In these cases, it's not necessary to demonstrate that the state is specifically affected by the conduct in question. So in the Gambia versus Myanmar case, Myanmar contended that Gambia's application against it was inadmissible before the court because Gambia was a non-injured party and had failed to demonstrate any special injury. But with a 15-to-1 majority, the court rejected this contention and held that the prevention of genocide was an obligation erga omnes partes to the convention, and any state party to the Genocide Convention could institute a proceeding regardless of whether it was injured. Notably, during the recent provisional measures hearing in South Africa's proceedings against Israel, Israel chose to leave the question of erga omnes partes standing unaddressed, and the court in its provisional measures judgment accepted that any state party, without distinction, may sustain a claim based on obligations under the Genocide Convention erga omnes partes. Whether the ambit of standing erga omnes partes will be extended beyond multilateral treaties such as the Genocide Convention and the Convention Against Torture remains to be seen. Finally, before a case can be brought before the ICJ, there must be a dispute. This is because, as the court explained in the nuclear tests case, the court is called upon to resolve existing disputes between states. Thus, the existence of a dispute is considered a primary condition for the court to exercise its judicial function. The question of a dispute, while seemingly a simple one, has been central to some of the court's most controversial cases, including the Southwest Africa case, where it was raised, and the nuclear test case. It also featured in the recent South Africa versus Israel proceedings and the preliminary objections in the Russia-Ukraine judgment handed down last week. The question of a dispute has been the undoing of a number of applicants' attempts before the ICJ. The question of a dispute is a matter of substance, not procedure, and it must be shown that on the objective facts, at the time that the application was lodged, the dispute had crystallized, inasmuch as the claim of one party was positively opposed by the other. Perhaps the most controversial finding of the ICJ on this score is the nuclear test case brought by the Marshall Islands. Now, the Marshall Islands was ground zero for some 67 devastating nuclear tests on its pristine islands, carried out as the Cold War arms race gathered pace. As a result of the nuclear testing, several islands were vaporized, and others are estimated to remain uninhabitable for thousands of years. In 2014, the Marshall Islands brought application proceedings before the ICJ and accused 9 countries of failing to comply with the 1968 Nuclear Non-Proliferation Treaty, which seeks to inhibit the spread of atomic bombs. The ICJ was unable to take up the case against 6 of the cited countries, China, France, Israel, North Korea, Russia, and the United States, because these states had not recognized and did not consent to the jurisdiction of the court. In relation to the remaining 3 respondents, India, Pakistan, and Britain, who had recognized the compulsory jurisdiction of the court, pursuant to Article 36, paragraph 2 of the court statute, the case proceeded, but a preliminary objection was raised that there was no dispute as defined. In a sharply divided 16-judge bench, 8 for, 8 against, with the president casting the deciding vote, the ICJ ruled that there was no evidence that the Marshall Island government's claims had established a prior dispute with any of the 3 nuclear powers, or that it had sought negotiations on this issue. The court upheld the preliminary objection on the absence of a dispute engaging its jurisdiction and declared that the court did not have jurisdiction. If I could please ask our technical assistant to put up the second picture now. To conclude, then, having considered the aspects of jurisdiction, standing, and the existence of a dispute, it can be said that we've walked up the long path through the gardens outside the International Court of Justice. We've noted the potential pitfalls to the unwary and the need to pass these thresholds to enter into that vast door of the Peace Palace. And only then is one invited into the courtroom itself, where under the watchful eyes of the allegories of peace and justice, depicted on the wall in an enormous 18th century oil painting by Giaquinto hanging over the court, can the merits of the real case begin. Thank you.
Kazi niyoba yini eThekwini ngaphandle wami? Ngilethele zonke izinto engingazazi lezi. Public international law, jurisdiction, local stand. Sefani ngilete ngibe mayor nje yenu. Ningibiza ngo-warlord, my warlord. Can I ask Funda Nkonzombi, Advocate Funda Nkonzombi, and to come and introduce the next speaker? She's in my chambers.
Thank you. Good afternoon, ladies and gentlemen. My name is Funda, surname Nkonzombi, and I'm a practicing advocate at the Durban Bar. I have been given this task to introduce the next speaker, and I'm very honored to introduce this speaker, and I say that because I had the privilege of meeting Advocate Sidiso Ramokgale in 2015 on the 20th of May. I even remember the time, it was between 11 a.m. and 12 p.m. It was at the Constitutional Court. I had received an invitation to have an interview with the former Chief Justice Mogoeng. So it was a law clerk position. So when I arrived, I was very nervous. I was still very young. So when I was there, I was just overwhelmed by the people that were there. And I met Advocate Sidiso Ramokgale, and he provided such excellent support and assistance in preparing me to meet the Chief Justice. Although I did not get the position, but I'm just very grateful and honored for the fact that I met somebody like him who prepared me for that. And I will never forget, hopefully I will never forget meeting him or that kind of assistance that he had provided me. Advocate Sidiso Ramokgale was called to the bar in 2018. He completed his undergrad studies in Bachelor of Law in 2014 at Wits University, where he was honored with the Vice Chancellor's Award, the Dean's Merit List in 2011 and also 2013. He was also awarded top student in constitutional law. In 2015, when I met him, he was appointed as a law clerk to the Honorable Justice S. Kampempe at the Constitutional Court. And in 2016, he was appointed as the legal officer of the South African Human Rights Commission. In 2017, he was appointed as a public international law lecturer at the Wits Law School. And in the same year, in 2017, he was appointed as an acting mentor program manager by Alan Gray Orbis Foundation. The same year of 2017, he also obtained his master's degree from Harvard Law School at the United States of America, where he also graduated with distinction. In 2018, Advocate Ramokgale was appointed as a lecturer at St. Augustine's College. And also in the same year, he became a member of the Johannesburg Bar. Between the period of 2019 and also 2013, Advocate Ramokgale was appointed by the Minister of Justice as a member of the Special Task Force for Land, Justice and Reform. Advocate Ramokgale has appeared in various courts in this country. Those courts include the Constitutional Court of South Africa, the Supreme Court of Appeal of South Africa, the Competition Appeal Court of South Africa, the Labour Appeal Court of South Africa, the Competition Tribunal of South Africa, the High Court, in fact, all of the High Courts of South Africa, the Labour Court of South Africa, the Land Claims Court, the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in public sector, including organs of the state. He was also a member of the Commission of Inquiry into the fatal shooting of Mlungisi Madonsela. His areas of expertise include constitutional law, administrative law, competition law, banking law, labor law, land law, claims and disputes, mining law, international law, and also customary law. He is also a member of the Alan Gray Orbis Foundation. He's a fellow of the Alan Gray Orbis Foundation. He is a member of the Pan-African Bar Association of South Africa. He's a member He's also a member of the Advocates Group 621 Chambers. He's also an editor of the Public Interest Law in South Africa. Advocate Ramokgale has over 12 Constitutional Court judgments. He has over 4 Supreme Court judgments, over 12 High Court judgments, and also judgments from the Competition Tribunal, the Labour Court, the Labour Appeal Court, the Competition Appeal Court of South Africa. With that being said, ladies and gentlemen, welcome Advocate Ramokgale.
An absolute pleasure. And that's the speech. Thank you very much. The only thing Funda forgot to mention is that I was the only member of the legal team that trended on Twitter. I don't know about the others. All right, so I know we've got the graveyard shift, so I will try and be short and to the point. So the focus of my speech will be on examining the existence of war crimes and whether the existence of war crimes in fact excludes whether you can make out a case for genocide. To do that, I'm going to be following the sage advice given to Lerato, which is to make 3 points. The first one was, what is a genocide? Adila has eloquently taken you through all of that, so I'm not going to repeat that. The second is whether the establishment of other war crimes excludes the possibility of establishing genocide. And then thirdly, I will speak about the forced displacement. You would have seen, if you've been following the debates, that some have argued that mass evacuations are war crimes and not genocide, and I will explain why, in fact, I disagree. But perhaps before we begin with those first 2 topics, it is important to hone in on one thing which came out from Adila's speech, that genocide is considered the crime of all crimes. But what is particularly important about genocide is the intention to destroy. And so what we look out for whenever we deal with the case of genocide is whether the intent to destroy has in fact been established. Now, a war crime is defined in Article 2B8 of the Rome Statute as the transfer directly or indirectly by the occupying power of part of its own civilian population into the territory in which it occupies, as well as in Article 49.6 of the Fourth Geneva Convention, which states that the states may not deport or transfer part of their own civilian population into a territory in which they occupy. In particular, war crimes refer to the activity of the state, the occupying state, in addition to that of an individual perpetrator, a detail emphasizing that its purpose is not merely to confront direct physical force, but also to oppose colonialism and its attendant structure of violence. Now, in the time allocated, it's not going to be possible for us to have a full lecture. I know, again, graveyard shift, so I'm going to get right to the point. However, there are a few salient points I wish to make. The first is that some have in fact alleged that acts may also be characterized, acts that are characterized as war crimes cannot be characterized as genocide. While genocide distinguishes itself from other international crimes as it requires special intent, it's paramount to stress that the crime of genocide does not require the actual killing of a protected group. A person may be held liable for the crime of genocide without any killings taking place, particularly since inchoate conduct, such as an attempt to commit genocide or conspiracy to commit genocide, are also punishable under the Genocide Convention. What is important always to underscore is the existence of intent. So in short, what we say is that it's immaterial whether the person ultimately achieves the goal of killing the group. What is important is whether they possess the intention to kill the group. So we do not measure genocide by how successful the operation has been. The mere intent is simply enough. That is because the convention intends to be proactive, not reactive. It doesn't have to wait for people to be killed. It's enough that there is mere intention. Secondly, the term destroy in the Genocide Convention, again, Adila took you through it, is also not limited to the physical or biological destruction of the group. It includes attempts to annihilate those linguistic, cultural, sociological, other elements which give that group its own legitimate identity and distinct identity. Often, attacks on cultural groups and religious properties and symbols of that target group often occur alongside and simultaneously with physical and biological destruction and may legitimately be considered to demonstrate the necessary genocidal intent. The International Criminal Tribunal for Rwanda, which rendered the first genocide conviction by an international court, held that in addition to killings, subjecting a group of people to subsistence diet, systematic expulsion from their homes, and the reduction of essential medical services below the minimum requirement constituted the crime of genocide as methods of destruction by which the perpetrator does not immediately kill the members of the group, but which ultimately seeks their physical destruction. So things like denying medical services, systematically expelling members of a group from their homes, creating circumstances that would, and you will remember this from the case, lead to a slow death, such as a lack of proper housing, water, shelter, clothing, hygiene, sanitation, and proper food, have all been examples that have been found to demonstrate genocidal intent. So genocide does not announce itself. It becomes manifest in deed, in spoken words, and also through actions. And to quote from Tembeka's speech at the ICJ, which I claim no part of, many propagators of grave atrocities have protested that they were misunderstood, that they did not mean what they said, that their own words were taken out of context. What state would actually admit to genocidal intent? Yet the distinctive feature of that case that we dealt with at the ICJ has been the silence as such, has not been rather the silence as such, but the reiteration and repetition of genocidal speech throughout every sphere of the state of Israel. I add to that the fact that a perpetrator did not choose the most efficient means to destroy the targeted group is not necessarily dispositive of a lack of genocidal intent. In fact, a particular contextual characteristic of the war crime as applied to the situation in Palestine is the rarity with which political discourse around Israel's settlement policy acknowledges its criminal nature. Addressing the notion of human shields in the context of colonial rule and the Israeli military policy, Judith Butler cautions that to assume that a war crime is easily recognized and that there will be general consensus that one has committed genocide is merely a wager. While the international community has been consistent in reaffirming that Israel's settlement policy is unlawful, such statements appear in the abstract, and there remains a broad refusal to recognize and to condemn the transfer of Israeli civilians into occupied territory as criminal activity for which individuals must bear responsibility. You have heard about Raphael Lemkin earlier, the scholar who is famed for coming up with the term genocide. And he said this: more often, genocide refers to a coordinated plan aimed at the destruction of the essential foundations of life, of national groups, so that these groups wither away and die like plants that have suffered a blight. The end may be accomplished by forced disintegration of political and social institutions, of the culture of the people, of their language, their national feelings, and their religion. It may be accomplished by wiping out all bases of personal security, health, and dignity. When this means fail, the machine gun can always be utilized as a last resort. So therefore, genocide is directed at a national identity as a group, and the attacks on the individuals is only secondary to the annihilation of the national group to which they belong. So when we really speak about genocide, threats of death, the knowledge of the impending death, can also constitute serious mental harm, which the crime tribunal specifically recognized as a form of genocide. It is about the fear of being captured, and at the moment of separation, the sense of utter helplessness and extreme fear for their families and friends' safety. It is a traumatic experience from which one will not quickly, if ever, recover. We have all seen the horrific numbers of Palestinians being removed from the Gaza. At the time when we went to the ICJ on our case, the number we cited was 80% of Gazans have been displaced. There's been a debate amongst international scholars about whether displacement itself in fact amounts to genocide or whether it's merely a war crime. And the short answer is that not all displacements are in fact genocidal. International law recognizes that forced removals are permitted under certain grounds, such as the evacuation of a civilian population from the population's security, or for imperative military reasons, and the evacuation of prisoners out of war, combat zones, or if an act of forced removal is carried out on such a basis, then what the law simply says is that it doesn't amount to genocide. It is, however, unlawful to use evacuation measures based on imperative military reasons as a pretext to remove the civilian population and seize control over desired territory. Although forced removal for humanitarian reasons is justifiable in certain circumstances, it is not justified where the humanitarian crisis that caused the displacement itself is a result of the perpetrator's own unlawful activity. The jurisprudence of the International Criminal Court for the former Yugoslavia consistently held that forcible transfer, including the removal of an ethnic group, is not itself a genocidal act, but could be an additional means by which to ensure the physical destruction of a targeted group. In this regard, a clear distinction must be drawn between the physical destruction of a group as an element of genocide and its mere dissolution. Only when the process of forcibly removing a population causes its physical destruction, therefore, does deportation or forced transfer qualify as genocidal act, particularly act of causing serious bodily or mental harm to the group. So in sum, forced displacement, war crime exists on a continuum. Collectively, what they demonstrate is genocide, and they cannot be read in isolation. When really and truly seen for their true purpose, they demonstrate a deliberate and systematic erasure of people. To end off on a personal note, practitioners in the space of international law do not look like Lerato and I. And I'll be honest in saying that I myself had never seen myself going to the ICJ. However, what I hope our appearance symbolizes is that no other young black lawyer will have the same thought. Thank you.
Yema Tonsel, ubani ozawundi introduce abantu? Uqhubeka ntona?
Ba introduce abafana abancane mina.
Ladies and gentlemen,
So ladies and gentlemen, this is our last guest speaker, and thereafter we will be ready for questions and answers as the program alludes to that fact.
Thank you. Ladies and gentlemen, good afternoon. My name is Simpu Ndlovu. I'm head of Parks, Recreation and Culture, one of your hosts today. I'm here to introduce a gentleman that doesn't really need an intro. I told him earlier on, I said, you know, because I saw that you've studied law, I tend to get into trouble in the city. So I want you to come in and represent me because the city manager sometimes threatens to fire me. Then he said to me, they will see. So Mpemba, I've got his back. He'll cover me. So ladies and gentlemen, when I was given his history, I said, you know what, if I were to go through the file, I will take until 9 o'clock. So rather, let me just keep it short. This gentleman is a senior advocate at Johannesburg. He practices in the area of constitutional law, competition law, labor law, land law, administrative law, and he has worked at the Legal Resources Center as the director of its constitutional litigation unit, and at Bowen Gillivan as a partner and a director. He's an author of 2 books, The History of Black Lawyers in SA, The Land Reform in SA. I will encourage him also to write a book about how the city of eThekwini hosted a very successful event, and I know he will. He's a professor of law at Nelson Mandela University and the University of Cape Town. Ladies and gentlemen, Advocate Mwaikomi.
Yabona ke Madonsela. Isebenzile ke. At least ndingathetha ke ngoku. After senindazi bani ngubani na. Umuntu avela athethe nje akaziwa. All right, thank you. It's 3 o'clock. You know, these people, I don't understand. I didn't say, I said, I'll give you a signal when to play it. They don't do it like this at The Hague. Avela bayifake nje. Yabona ngiseThekwini ke ngoku. Anyway, sesaniyeka ke seyilapha, you know. But bendithe uMadonsela ngizawunika isignal. But uMadonsela ayacaca nyani ba. Kubi. So I just want to speak on history. So Tsidiso has covered the field. So I want to first thank you, Advocate Madonsela SC. He was once my leader in a case we did here. Very important case that led to the exclusion of certain delegates from voting at Nasrec from a certain province. And I won't say which province. And I also want to thank my 2 juniors. I had 2 juniors at The Hague, Lerato and Tsidiso, who prepared my speech. I was just the spokesperson. And obviously my colleagues, Max Duplessis and Adila Hassim. It was really a pleasure to be involved in this case. So, I mean, they have spoken about how we went there, etc. And of course, Sarah was there as part of the team. But you see, Sarah, she's South African, but she lives in Netherlands. So, what's going on exactly? Why do you live in the Netherlands? So she's a true international lawyer. So we are grateful that she's back for a couple of days. She tells me she's leaving again on Sunday and she'll be back again in a month. So yeah, it's a truly international team. So our topic with Tsidiso is around this concept of genocide versus war crimes. But I want to introduce another category, which is crimes against humanity, because we haven't really spoken about that. But I want to locate what I'm going to say in a little bit of history, history of the terms, history of the concepts. On the 24th of August, 1941, there was a meeting between Churchill and Roosevelt. So this is the dying days of the Second World War. And basically what they have to decide in this meeting is what will the world after the Second World War look like? What are the principles that will govern the world? But at the same time, the war is still raging in Europe. And Churchill introduced this phrase. He was a master of phrases, Winston Churchill. I mean, he was a raging racist, but but he was a master of phrases. So this is what he says when he issues a public broadcast reporting on the meeting with Roosevelt. He says, "We are in the presence of a crime without a name." Right? And he is trying to capture the atrocities of the Nazis in Germany against the Jews. He says that we are in the presence of a crime without a name. But maybe he should not have been in the presence of a crime without a name if he had been familiar with the Belgian Congo of 1890. In fact, the person we also have to thank is George Williams. He's a black man. That's the man who is there on the screen. It's George Williams. Because he is the man who actually recorded the atrocities of the Belgians in the Congo. He did not have this term, genocide or genocide, but he had the other term, crimes against humanity. So after describing the atrocities of the Belgians in the Congo, he then implored the Secretary of State in the US to establish an international forum to try the Belgian settlers. He says all the crimes, this is what he said, all the crimes perpetrated in the Congo have been done in your name, and you must answer at the bar of public sentiment for the misgovernment of a people whose lives and fortunes were entrusted to you by the August Conference of Berlin. Chris made an excellent point here that most international lawyers see their endeavor as benevolence to the people of the global south. And they look at the role of international law as being to include us, to incorporate us within the family of the civilized nations. They don't think about the fact that we don't want to be included. We actually fine without them. So that was the same sentiment even with the Berlin Conference, 1884, 1885. And then he continues, I now appeal to the powers which committed this infant state to your Majesty's charge, and to the great states which gave it an international being, whose majestic law you have scorned and trampled upon, to call and create an international commission to investigate the crimes herein preferred in the name of humanity. Right? So according to Bill Shabbos, this is the first time the phrase crimes against humanity is used. So he has, George Williams has been erased in scholarship, in history. Okay, anyway, I'm going back to my origin. I'm the guy that looks after dead black lawyers and try to bring them into, anyway, so I can't help myself. But anyway, he has been erased, but that phrase he originated, not in relation to killings in Europe, but in relation to killings in Africa. And why this is a particularly important point is that there had been 2 other mass killings of Africans prior to the Congo mass killings, right? There were mass killings in the Eastern Cape. Already, announcements were made in 1812 of destroying all of the natives from the Cape to Natal. Those are the phrase. I want to destroy all of the natives from the Cape to Natal. The fellow's name is, you know him? All right. You know Smithfield. We had never heard of Smithfield. So who was the Smith? And there were also killings here, right, in 1879. If we had the language then, those killings would have qualified as genocidal. So they were trying to clean up the space for European settlement. But the black man in the Congo in 1890 already coined the phrase, which in Europe has never been used. But the immediate context, of course, is the Second World War. And Adila and Tsidiso have spoken about Raphael Lemkin and his concept of genocide. But he is also competing with another scholar, Hersch Lauterpacht, who is credited now in the book East-West Street, which I think is wrongly credited, but anyway, that's there, for having coined the phrase crimes against humanity, Hersch Lauterpacht. And the two of them are debating, well, how are we going to describe the atrocities of the Germans over the Jews, right? So because the reason they have to do this is because they have to issue a charge sheet. So Germany has been defeated in the war, and Hitler and his goons have to face the music. They have to issue a charge sheet. The charge sheet can only be done in legal terms. So they need to know what are the charges that we're going to place against these people, because what they have done, according to Churchill, is a crime without a name. According to Hersch Lauterpacht, he reverts back to the old phraseology of George Williams, the crimes against humanity. That what we are going to describe is crimes against humanity. And Lemkin says, but this is not enough because it doesn't capture the essence of what Hitler was trying to do to the Jews, which is the intention to eliminate, to destroy, to wipe out. You know this, to wipe, not just a mass killing, but the idea that if you went to the pogroms or if you went to those places like Auschwitz, the intention is that nobody gets out of Auschwitz alive. Like nobody gets out of Auschwitz alive. Now, precisely the same intention as in the Congo. Nobody gets out of the plantation alive. Same intention as in Namibia. Nobody gets out of the concentration camp alive. Now, that is what distinguishes a labor camp where people are enclosed to work with a death camp. So Auschwitz then becomes a death camp. So the two scholars are trying to debate this. Well, how are we going to describe what the Germans have been doing? And they say the real issue, according to Lemkin, is the intention of places like Auschwitz, where death camps, not labor camps, not concentration camps, but death camp. If you get into the camp, you don't come out alive. And that is then the essence that distinguishes. So Lemkin tried to introduce this into the indictment. He did succeed. The indictment did contain genocide. But the findings of the court did not contain a genocide. Instead, what they did, they found the Nazi criminals guilty of crimes against humanity. And that, in fact, became the sole measure of the atrocities, crimes against humanity. So genocide still remained this crime without a name and crime without a convict until many, many years. And obviously, you've heard from Adila that it's included then in the 1948 convention. And the way it's included there is also interesting because it uses the word following acts, killing members of the group. That can also be a war crime. That can also be a crime against humanity. But then it uses the phrase intent to destroy. So it's not any intention. It's the intent to wipe out, right? Get rid of everyone. Get rid of all of the Jews. Right? And then it says, in whole or in part, national. So, like Harry Smith wanted to do, I want to kill all of the natives of the Eastern Cape and of Natal. You think, guys, you thought you were safe? No. It was the natives of the Cape and Natal that Harry Smith wanted to wipe out. So, and he doesn't have to intend to wipe out everyone. He only needs to intend to wipe out in part, right? I mean, in the Eastern Cape, through that cattle killing movement, they finally killed 40,000 Xhosas, which was a population reduction of 30%, and 400,000 cattle. Economies based on cattle, they wipe out everything. And in Belgium, they killed 20 million Congolese. So in Congo, 20 million Congolese. And in the slave trade as a whole, primarily concentrated on West Africa, 14 million. But these descriptions are actually not used in relation to Africans. And then it says, well, in whole or in part, a national, so we know at least what a national is, ethnical, racial, or religious group. As such. So there are some exclusions. So if you want to kill only women, that doesn't seem to be included. If you want to kill only men, that is also not included. If you want to kill only children, that also is not included. If you want to kill only gays, not included. Only lesbians, not included. So because of its origins and history, so it must be national, ethnic, racial, religious as such. So those are the narrow. So the acts themselves, so the intention must be the intention to wipe out, the intention to destroy. Right? And you can destroy, as Sidiso says, by shooting people around or giving them poison or pushing all of them into Auschwitz. Or you can just starve them. So, and you can do it in 5 ways. You can kill them. You can cause them serious bodily or mental harm. You can deliberately inflict conditions of life calculated to bring about its physical destruction in whole or in part. You'll see this particular phrase coincides with another convention that would be familiar to us, namely the Apartheid Convention, which is a crime against humanity, but not necessarily genocide. But there is an overlap nevertheless. Imposing measures intended to prevent births within the group, forcibly transferring children of the group to another group. So when it comes then to intention, it's important. Sidiso says, look, usually what distinguishes this is the intent element. So it could be direct intent, or I saw an article about the controversy of dolus eventualis in genocide cases, but it could also be dolus eventualis. But you must always have the intention to destroy the group as such. And you can do it in these different ways. And the court itself, it seems that it has adopted a narrow definition of genocide to basically the attempt to bring about the physical annihilation of a group. Any other thing would then not fall within the definition of a genocide. And so those who want to litigate in the area, you would do well to distinguish cases where it's stage 1, which is provisional measures. That's, our lawyers are familiar with that. It's otherwise interim relief from final relief or so-called merit stage. At the stage of provisional measures, you don't have to prove an intent to destroy. Right? You just simply have to prove that the acts that are committed are capable of falling within the definition. In other words, there is a plausible basis to say that the acts are capable of falling within the definition. The same thing with intent. I struggled at the beginning because I'm not familiar with the subject about precisely how to establish intent. And intent can also be established not only by what people say they want to do, but it can also be established by the pattern of conduct, provided that pattern of conduct is consistent with only one inference, which is an intent to bring about the physical destruction of a group or part of the group. So you must just remember that. So we then go to another concept. I think you've heard enough about genocide and what you have to establish on the existing jurisprudence of the court. We go to another concept, not war crimes, but crimes against humanity. Now, you see this defined in the Rome Statute. So the Rome Statute contains 4 crimes when it was enacted. 1 is genocide, 2, crimes against humanity, 3, war crimes, and then 4, which was a controversial crime at the time, it's the crime of aggression. A lot of scholars argued that when Russia invaded Ukraine, it should have been charged with the crime of aggression. But we know that it was inside the Genocide Convention that the individuals, rather, were charged with the crime of aggression. We know that it was the the Genocide Convention that was invoked. So one distinguishing feature here, which is very crucial for people that are interested in this area, is to recognize that the Rome Statute is the statute that is designed to impose individual liability, right? Not state liability, individual liability. So that's why somebody like Putin, Max was talking about the Putin case, receives a charge sheet, not Russia, under the Rome Statute. That's why someone like Ali Bashir receives a charge sheet and not Sudan, right? But under the ICJ mandate, it is only states that may be cited for violations of the convention. So the Rome Statute is intended to complement the ICJ statute by moving beyond state and targeting individuals within the state. So in a sense, it cuts off that state protection that is usually cited. And then it identifies the 4 crimes for these individual liability: genocide, crimes against humanity, war crimes, and the crime of aggression. And the genocide definition is the same in the Rome Statute as it is in the Genocide Convention. Although there's one important fact, it's the forcible transfer of children, right, which was the hook they used in relation to Putin. Max, you didn't mention that actually we settled Putin on account of the advice that some of us gave. He just says, no, the case was settled. Where did the settlement come from? Yeah, no, some of these colleagues of ours. So anyway, so children are included specifically in the Rome Statute, but you won't find a comparable feature in the Genocide Convention. And then there's a long definition of crimes against humanity, right? So, and what you will see here is that that element that says with the intent to destroy is not included. So it means the following acts when committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack: murder, extermination, enslavement, deportation or forcible transfer of population, imprisonment, torture, rape, sexual slavery, persecution, enforced disappearance, and then J, the crime of apartheid, right? Other inhuman acts of a similar character, intentionally causing great suffering or serious injury to body or to mental or physical health. So what you can see is that crimes against humanity are a broader category, and the genocide is a narrower of those 2. And then war crimes. So what you should be familiar with if you want to study about crimes against humanity is the Rome Statute plus the Apartheid Convention. There's a convention on apartheid published in 1973. So it would be, yes, 1973. And then, of course, there's war crimes. And there, the main convention is the Geneva Convention. It's when people violate the Geneva Convention, they can be charged with war crimes. But there is still a full definition there under the Rome Statute. Now, this is now the final point. There has been a debate among the leading scholars of international law about the efficacy of genocide as a standalone crime at the very top of all crimes. I mean, Adila refers to it as a crime of crimes, right? And Winston Churchill said, we are dealing with a crime without a name. About the effectiveness of that distinction, because it overlaps substantially with crimes against humanity. It also overlaps with war crimes. It also overlaps with crimes of aggression. Overlaps also with the Apartheid Convention. So the point that has been made is why then should we keep the Genocide Convention? Because from the perspective of a victim, a killing is a killing. Whether that killing is intended to kill only that particular individual, or whether the killing is intended to wipe out an entire ethnic or racial group. from the perspective of the victims, a killing is a killing. So what is the point then of keeping this distinction? Shouldn't everything simply be referred to as a crime against humanity? From what I read, that seems to be the view taken by the author of East-West Street. What's the name of the juicy? Philip Sands. That's the view that it takes, that it's time to reconcile these two and to treat them as one and the same, because the impact is the same. But he also says there are further methodological problems with maintaining this distinction. Right? The one methodological problem is the narrowing of genocide. But he also says there's a further problem, that when it comes to people lodging charges, there's a general temptation to move to genocide, because every suffering group wants to enlarge its own suffering as the biggest and the worst in the entire history of suffering. And so he then says, well, we don't need this Olympics of suffering, because suffering is suffering. You know? What we need is one uniform standard that refers to the killing of many people. And that also makes it easy from an evidential perspective to put a case to court and to establish the case and the facts, and people can be found guilty or liable. So those are the additional points I thought I should make. That should be, I'm not even going to try, because I had another picture. I don't know what's going to happen. Let's forget about, because I still wanted to show the picture of Hersch Lauterpacht and the picture of Raphael Lemkin, but it's two white men, so I've got a black man on the screen. Thank you very much.
Thank you, Temberger. Can I ask you to give yourself a round of applause, because you have been a good audience. I mean, from morning till now, we have really behaved, and we have been sitting settled, concentrating and listening to every word uttered by the speakers. Thank you very much.
Oh, don't go.
I'm bad. Now it's time for you to speak, if you will, and ask any questions or make any comments. And we are right on time, and we have made the time. We didn't waste time on any other aspect. All those who want to say a word, or want to comment, who want to ask questions, can you please, do you have a revolving mic? There they are. So there is a light here, I can't see clearly.
Good afternoon, colleagues. Name is Abin Badal. I work in the city. Just to say that in December, when this case was heard, I, like thousands of South Africans, never felt so proud of the team and our country on that day. So big ups to the team for really putting South Africa on the map. Just a few comments and perhaps questions. I can't seem to get the minority judgment of the Honorable Julia Sebutende. I don't know if it's in the public domain. When the CM doesn't overwork us, maybe we can go through it and comment on it. So if you could just refer us where we can get that judgment, we're quite interested to find out thought processes there. Secondly, various speakers have made referrals to both Presidents Putin and President al-Bashir and the warrant of arrest and the execution in South Africa. But what do? We have Prosecutor Karim Khan from the ICC. Various attempts have been made to issue warrants for, an example, President Benjamin Netanyahu, and he does nothing. So what is the legal resource of where there are legal instruments like the ICC, where the prosecutor simply does not respond? So that is really problematic for me. The last comment is in terms of provisional measures. I'm not quite sure when the month is up, but it appears to me that the state of Israel is not complying and doesn't intend complying. So if you leave the political aspect of it, what is South Africa's next step in ensuring compliance? Thank you.
Thank you. Can I ask Chris to answer the question of the judgment? And can I ask also to Max to answer the issue of warrants? I don't want anyone from the legal team to answer the third question. Chris, can you answer the third question about what is the remedy if there is no compliance with the provisional measures? So, Chris, can you come forward first? Oh, there's a wrong mic.
Thanks, Council. So I'll be brief. So the first question, the separate opinion is on the website. You just have to look for it. They might be hiding it because of the contents, but it is there. And I can direct you to that afterwards. On the question of the RCC, I think, and I can say this as an academic who doesn't have to observe protocol. So the difficulty with the RCC is in some senses a difficulty of African states' own making, because when we formed the RCC, African states were very keen to get an independent prosecutor. So the Global North wanted a court that was completely the handmaiden of the Security Council. African states pushed very hard to have an independent prosecutor, with the view that that prosecutor would go after the great powers and would exercise their office without fear, favor, or prejudice. What we didn't account for, perhaps naively, is what happens if we get someone in that office who doesn't want to do the right thing. So that prosecutor is very much shielded from being disciplined for inaction, and I think at this point, that's the only way to describe the conduct of Karim Khan, is as I've described the public, I'll say it again, as feckless and lacking spine. And I think there's no real way around that difficulty because we have secured his office so much from interference, short of removing him for violating the terms of his office, which would be very difficult. So the alternative to that, as it always is with the ICC, is domestic prosecutions and other forums of justice. So there are definitely those modes available.
Thanks. Max, do you want to say a word?
Thanks. I'm involved in the ICC matter, so luckily I'll say nothing, but I can say this about universal jurisdiction to pick up on Chris's point. The structure of the Rome Statute specifically envisages that the International Criminal Court is actually meant to be a court of last resort. The first order of priority should be by states taking action under their own domestic jurisdictions and statutes to open cases and to gather evidence and to share information, and prosecutors to meet in order to make a network of domestic states who have the ability to issue arrest warrants, limit the travel of people who are implicated in such crimes, and the name says it all, exercise universal jurisdiction. And I think that anybody that's been watching what has taken place currently must accept that that should be where the priority lies.
Tell me, if a head of state was to commit war crimes and is prosecutable domestically, will he still be liable for arrest and prosecution in the ICC? Or will he be protected by double jeopardy?
No, so you'd be prosecuted in your particular court, and you would then have relieved the International Criminal Court of the obligation to prosecute, because you end up as a conduit, effectively as the assistant to the ICC. So that would be where the crime is ultimately prosecuted. And Tebeka has just highlighted that as it's not only Switzerland, I think there may be others, but Switzerland, for example, is investigating Netanyahu on a universal jurisdiction basis for the crimes that have been committed by Israel. And there may be one or two other states as well. And South Africa obviously has its own legislation by which these types of crimes could also be investigated at a domestic level.
Sometimes mangibuza imibuzo ngisuke ngibuzela nina nje. Inisiza. Any other question? Can I please invite Advocate Sporas Jigela SC and the city manager to come forward as we conclude this day? Okay. As we are about to conclude this day.
Thank you.
Professor Matungwa.
Ngiyabonga. Uma esehambile umadonsela for mayor. Mfethu. Zoliphakamisa igama lakho. Thank you. Why am I standing?
Oh, you can stand. You can stand up, please.
Please.
Please. If you wish.
Okay. No, thank you. I would leave the ultimate thank you to Babu Mpele. But really, what a fantastic day. All the speakers, amazing. Okay, so I'm thinking around this time on Fridays, we sit with the boys, somewhere in our watering holes, and we are looking at the events. No, serious. This is how we wind down the week. We are revisiting everything that happened during the week. So this Bashir thing comes up. So what happened? The guy was here, they let him go. All kinds of theories come up. Oh, good connections, he paid this, that. I cannot wait to fill them in. You guys have taught me what really happened. How did we let him go? Now I know. So part of it, I'm emphasizing the importance of this kind of sharing of information, because really we made our conclusions, closed, he's left. Okay, let's leave that one. Now the case of Putin comes up. Are we going to really, really, really arrest Putin if he decides to come? Can we imagine him in one of our vans, SAPS vans, picking him up and where are you going to take Putin? Which jail? Where are you going to keep him? Of course, we drew our own conclusions. No, these guys are joking. Putin is going to come and he's going to go. So now we are led to believe that Putin didn't come because we were going to arrest him. Really? Really? Somebody tell me something else. The Bashir case, I heard it, understood. Putin didn't come because Putin didn't want to come. That's what I'm thinking. That's what we concluded. Tell me something else. Somebody. What's the other one?
Putin didn't come to South Africa, I can tell you.
I know that.
If he had come, we would have known. And we would have arrested him.
The other one, for me, this international story, international law. I'm seeing the world breaking down into these little factions, the Global South. ECOWAS just dismantled not too long ago. I'm seeing us breaking up into these little factions. And this notion of something international, I'm not buying that story. But you guys are trying to convince me that there's something going on with this international Hague and this. And by the way, somebody pointed out, Israel is continuing to bomb. So what now? We don't have a court, we don't have army to enforce the decisions that we make. So I don't know. I think somebody needs to speak to that too. What now? I heard a little bit, but I'm not too convinced. For me, the world is breaking down into these smaller and smaller and smaller units. Putin is doing whatever he's doing in that part of the world. Netanyahu is continuing with his thing, and nobody's doing anything. So I think I'll stop there. Is that two?
Thank you. Thank you. Is there any other question or other comment? So that we deal with them once, all in once. Andreas, are you going to respond? Yeah. I've got 2 hands, 1, 2, and 3. Then we'll bring the program to a close. But before you comment, mfowethu, Ngcobo ne?
Yebo.
Oh, ngiyakubona. Before you comment, Mapoloba, can I please acknowledge the presence now of our Minister of Judge Ngozi, who I've just seen him seated there. Thank you for coming over. I invited him. You know, ngaziwa na amajaji ni. Get connected. Of course, I also want to acknowledge in our midst the presence of one person who's an important person, Batabile Madonsela, my wife. Yes, Mapoloba, can you please come?
Thank you, SC. My apologies. I arrived a bit late, but I was fortunate to hear what Advocate Ngugai Tobi was articulating in terms of the case.
Did you hear? Was he the only one who heard?
The reason why I'm talking about that particular point is, as much as this is a global discourse engagement, there's also a local discourse in terms of, let me not say it specifically for reasons of decorum, but I'm a business person and we suffer all forms of crimes on a daily basis. But I want to latch on the comment on how do you conclude intent? What sort of maybe case law that we can look at in terms of the repeated pattern of behavior? There was a sweet spot in my reasoning there. Maybe he can assist to just to enrich that topic. Thank you very much.
Yes, there was another hand there. Ngama?
Thank you so much. Yes.
Yeah. He's one of the BLA stalwarts.
My name is Ntlagani Pongema. I am an academic and legal research officer for the Black Law Association Student Chapter from the National Executive Committee. And I'm a final year LLB student. My question goes to the city manager. And I'm sorry, I didn't mean to personalize it, but I think I should ask it. Given that Durban is one of the tourist destinations and the current developments, what impact do they have in your office, if there are any impact? And if they are, what then that put us, or rather, the future of your office? Thank you so much.
Yes, sorry, I nearly missed it. Chris, here's another academic asking a question.
Good afternoon, thank you so much. My name is Lubna Nadvi. I'm an academic based at the University of KwaZulu-Natal and an activist for the KZN Palestine Solidarity Forum. As an activist, one of the things that we're very concerned about, and this is a question to our legal experts, is the slow pace of how international law works and how slowly justice actually gets to, the sort of victims, and particularly in the case of Palestine. So I'm asking a question about, the other speakers have also raised the question of the fact that Israel is still bombing Gaza, and that, that situation continues. 30,000 plus people have died in this most recent spate of attacks. So I have a concern about the slow pace of international law and how it works. So I wanted to just ask the experts about when will we actually see justice for Palestine? I mean, of course, I'm not asking about when Palestine will become a state, but just in terms of the issue of the killings and the genocide and all of that that's happening. So I'd love to hear from the lawyers about that. Thank you so much.
Thank you. I'll ask Andreas and Tadisa to cover the questions that have come through. If Tadisa, it won't affect your involvement in the case. to the extent that you can. There is a...
I'm just going to try and answer the question about Putin. And the speaker's question is a fair one because it's indeed a question which the president put in the papers and indeed put to the ICC, which is, were we to comply with our obligations under international law, you would put us in an impossible position because Russia would declare war on us and they are a nuclear state. And they said that. I mean, that is in the papers. I don't think I'm misstating that. But ultimately, the government, under the advice of Tembeka and Kaitobi, SC, accepted what the ICC said and what its legal advisors told it, which is that there are these impossible positions sometimes where the law does bind. When it binds, when it hurts the most, when it hurts when you have to arrest a friend, when it hurts when you have to do something which puts you in a difficult position. But it's precisely at those times when the rule of law matters more, not less. And so our government ultimately did the right thing there, which is to say to Putin, it may cost us much, but we will follow the law. We have to. Our police force will. So please don't come. And indeed, Mr. Putin thought, I won't come. And let me add one little last point of realpolitik. I'm sorry for anyone. I speak on my own behalf here. But I've often thought, as someone who's always very interested in realpolitik, this. While Mr. Putin would hope that if he were to be arrested by South Africa, his military would come to his aid, when you're a dictator in a country, as many dictators have learnt, sometimes when you go overseas and get lost there, your country doesn't come to your help. The next man says, I'm now in charge, thank you very much. So maybe that's another reason he didn't come.
Citizen?
I'll answer the question about intent. I thought I had covered it in my section, but seemingly not. There's one book I'll recommend, which I found to be quite illuminating. The book is called, it's published by Oxford, it's Public International Law, and the chapter in particular is International Crimes, Law and Practice, Volume 1, Genocide, by Ganuel Matero. Part of doing ICJ cases, you start speaking French. So Ganuel is spelled as G-U-E-N-A-E-L. Matero is spelled M-E-T-T-R-A-U-X. That's probably, of all the books I've read, the clearest exposition on genocidal intent.
Yeah. Intent, And Professor Mkunu, you must also know the word, or words, dolus eventualis. Then you'll find genocidal intent. Is there a Adila?
I don't need a mic, I'm sure I just want to respond very, very briefly to Lubna Nadi's question, because it's quite important about the pace of international law and the fact that the bombings continue. I'm not going to speak about the case, but just that I don't think it's just a problem of international law. International law has its own unique set of problems. The problem of law and trying to use law to achieve political ends and trying to change the power dynamics. I think that is part of what the drawback is. The expectation that a case can change things quickly is not a realistic expectation. But what it does is that it does change dynamics, it does place more pressure, it puts moral pressure in places where it needs to be, it gives impetus and emboldens movements within countries where it needs to happen, including in this particular case in the US, because that's where that's where there needs to be. And so you've seen the challenges that come from civil society within the US, which I think is important. And so this kind of impact is a part of something else, but I don't, law, I think a lot of people expect more from the law than it can ever give. But that's not to say we mustn't do our best.
Tamara?
No, I just want to add one thing on this point that Adila is saying. I mean, because, the funny thing is that, we who are constitutionalists at home are also constitutionalists abroad. There's lots of people, this constitution is so useless, we're still so poor after 30 years, So that's the kind of skepticism that one must always guard against. But the serious point I want to add is this. The people of Palestine know that they are not alone. That's very, very important in the ongoing struggle. They know that the South Africans are with them. We must remember this as blacks in South Africa, because when you suffer in a corner, no one is watching, no one is doing anything, you tend to think that I'm actually alone, I'm fighting an impossible struggle. Because a colonial occupying force, which is what Israel is, a colonial occupying force is an intimidating thing. It is a big thing, it is an intimidating thing, particularly when it has the support of the US and the UK. Blacks know this because the whites had the support of Margaret Thatcher. They had the support of people like Reagan. They called Nelson Mandela a terrorist. Every second statement you hear about Palestine is that terrorist organization, terrorist individual, 3 terrorists killed, etc. But today, the Palestinians know that they have friends everywhere in the world. This is the power of a court case. It's an immeasurable thing, the power of a court case. It's shining a spotlight on suffering. It's not ending a war, but it's shining a spotlight on suffering. And that is one cog in a big machine.
Can I steal the mic for a second? Because I just wanted to talk about the speed that you mentioned and the slowness of law. But I think one can talk about a spotlight, and just be gobsmacked that on the 29th of December a case was launched. Do you think Israel for a moment thought that they would have to answer for anything 12 days later, on the 11th of January? The International Court of Justice issued a timetable which was incredibly rapid. And within the space of 12 days, the entire focus of the planet was on the plight of Palestinians and what was happening in Gaza. I think that that's the speed of justice and the ability to put that spotlight there as quickly as happened before a very serious tribunal. And I've said this elsewhere, a serious dispute, seriously litigated. Israel sent serious legal team to The Hague, seriously adjudicated. That's unbelievable for the international rule of law.
Advocate Morane SC is a Latin master. He had to correct us in Latin. If he was to answer that question, he would say something like this, but boys, please correct me again. Festina lente. What does it mean? It means slowly. The law hastens slowly. Somebody?
Something that's
Sorry, can I just
Yes.
say, she must be allowed all the time to speak because she briefed me, or the firm briefed me, in the South African Human Rights case, Commission versus Sunduzi Municipality landfill
Thank you.
case.
Thank you. Good luck, Mr. SC. Something I don't seem to be understanding, and maybe it's because it is not fair, is this sort of veto Security Council issue. And Sarah mentioned then earlier that there is, some of the parties or members of the UN, the ICJ can then submit reservations. And it seems like the parties that have the veto are the ones that have submitted reservations. So does that mean that they can veto any enforcement from the Security Council, but also not be subject to the Hague or the ICJ? I mean, I don't understand it, but for me, it seems like completely backwards.
Yeah, that has been the criticism of the, but anyway, Chris, would you like to enlighten us there?
You're very close, so using a mark seems strange, yeah. Let me sit back a bit so it seems more. So the quickest way to explain the veto is that in 1945 there wouldn't be a UN without the veto. But in 2045 there won't still be a UN if there's still a veto. So the veto is both the necessary condition for the UN and its biggest stumbling block. It is the reason that you don't see the action that people expect, both from the Security Council, but also from the court. So one of the benefits of going to the court is you can get a Security Council to enforce the measure. A positive reading of the kind of vagueness of the order in the provisional measures was that it opened the possibility of a Security Council enforcement, although that most likely won't happen, particularly in light of recent events. But I think it's important also in this to remember that international law is not a centralized system, it's not a fair system, and the Security Council has a lot of power. But states do too. So one of the consequences of the provisional measures order is it loosens the reins on other states to take measures against Israel that would otherwise be unlawful. And there's a whole lot of energy that goes into us focusing on the Security Council, whereas what states should be doing, what civil society should be doing, is focusing on their government's ability to take certain concrete measures against Israel in light of the judgment. So we put too much faith in the Security Council and we disempower ourselves, both in communities and as states, to take lawful countermeasures.
Bye-bye, Adila. Thank you very much for... Thank you, Adila, for coming over. Thank you very much. We've come to the close, to the end of our program. We're right on time at 4 o'clock. May I please ask the municipal manager, Mr. Mbeda, to come and give a closing vote of thanks. But in case he forgets, can I just thank two individuals who were very central to the success of this occasion. Malus Mhlongo, head of legal services, who was up and down with me. We had many hours of talking and chatting about this whole thing. He pulled it together. Thank you very much, Mfowethu, for assisting. Secondly, there is a lady you were RSVPing to, Wenzile Zama. She's in the meeting of the BLA in Sun City. She pulled this thing. If it was not for Wenzile, this thing would not have happened. She organized all the logistics and communicated with everyone who needed to be communicated with, and it is through her that this whole symposium was an absolute success that it has been. I was utilizing a travel agent because we had to travel to transport our guests from Johannesburg, and I got into touch with my travel agent, who's not here, Angelique Buckley. Angelique Buckley from Corporate Travelers. She is the one who was communicating the flights for all the guests from Johannesburg and accommodation and transfers. She really relieved us of a huge logistical nightmare. I want to thank her in absence. I don't want to go to the Ethekwini team. The city manager is here. He's going to do that. Last but not least, I want to thank me. For working tirelessly for this. You know, all glory goes to the Lord. Amen.
Program directors, Advocate Madonsela and Malusi Mhlongo, His Worship the Mayor, Councillor Mxolisi Kaunda. Councillor Kaunda, whilst you were busy somewhere, Advocate Madonsela did say that he wants to become a mayor. So you have a competitor here. Deputy Mayor, Councillor Mieni, Speaker of Council, Councillor Nyawose, the esteemed legal team that has represented us so well, the members of the legal fraternity, and different institutions that they represent, ladies and gentlemen, I'm here to give a vote of thanks. But in government, it is very normal to confuse a vote of thanks with concluding remarks. I want to say that I'm by no means qualified to do any concluding remarks after such a fruitful and insightful discussion by the greatest legal minds, not only in the African continent, but across the globe. However, as a senior public servant, please do allow me to say just a few words. Even though I don't qualify to make concluding remarks, they are not concluding remarks. They are just my observation, and they come from the heart. South Africa has once again projected itself as a moral beacon in the space of social cohesion, peace, and reconciliation during the global geopolitical conflict. As a country, we have stood tall above many countries in the world which have chosen rhetoric in favor of or against what is taking place in Palestine, which has now transformed into a full-scale Middle Eastern regional conflict involving the countries of Lebanon, Syria, Yemen, and possibly the Republic of Iran. Notwithstanding complex politics which have sought to eradicate the moral character of international institutions such as International Court of Justice, South Africa still has confidence in these institutions. These institutions are meant to become a vanguard of peace and reconciliation, but their impartiality has been questioned recently. South Africa has chosen to do what is right, and they've decided to decisively make this move. We taught the world that law is a powerful instrument in the hands of a peace-loving nation to solve complex international conflicts. In the days where wars and talks of wars are rife across the globe, South Africa has once again proven that what we did in 1994 when we became a rainbow nation was not a fluke. We have shown the world that a rainbow nation was born out of a genuine commitment to achieve peace and reconciliation, and given a chance, we can also display this conviction and commitment in the whole world. We are a country of many great talents. Despite the socio-economic challenges, we have shown the world what we can do across many sporting codes. But in this case, we have also been very consistent in proving our dominance in the space of international law. Indeed, through this victory, we have proven what the father of our nation, Dr. Nelson Mandela, inculcated in the form of peace and reconciliation, that dream is still alive. We are very grateful to these extraordinary South Africans who have made this project a success. Siyabonga. Namhlanje sikwazi ukuqhawula ongcuka ithobi abantu esigcina sibabona ku TV angazi ukusigeza isandla for the next couple of days. Mhlambe nami ngizogcina sengikhuluma nge-Roman Statute and the Genocide Convention. My job here is to give a vote of confidence. I nearly said a vote of no confidence. I'm thinking about Madonse. I'm thinking about Madonse. So I want to thank the following people and institutions. Firstly, the people of the Republic of South Africa for standing behind our government in pursuit of this noble cause. President of the Republic of South Africa, Matamela Cyril Ramaphosa, for leading the country through this period where we were able to make this decisive decision in pursuit of social cohesion. The ministers of DECO, Justice and Correctional Services, for leading from the front and putting together such a strong team. The legal team from the city, Oma Lusimhlongo, Omtandeni, but also working so hard to ensure that this event becomes a success. And I've committed that we are going to have this one every year. So I'm looking for the same commitment from various organizations such as the Black Lawyers Association, South African Journal on Human Rights, and Advocates for Human Transformation for supporting and sponsoring this symposium. His Worship the Mayor of eThekwini, Councillor T.M. Kaunda, and senior leadership of Council for giving us permission to have an event of this nature. Our program directors, Advocate Madonsela and Malusi Mhlongo, respectively, for steering the ship so well. Our social cohesion team, led by Dr. Musa Kumete and Dr. Simpiwe Ndlovu, for sponsoring all these flowers here and paying for the venue. Thank you very much. And she's telling me that I must declare whether I passed in summa cum laude or what. All I can say is that I passed loudly. And finally, you, ladies and gentlemen, for being such a wonderful audience, and you have participated so well, and you have been very respectful. You listened attentively. A round of applause for yourselves would be very good. Before I take leave, I would like to request the speakers to come forward for the city to give a token of appreciation to all of them. And thank you very much. Have a lovely day.
May I also ask Mr. Solomon, who is the founder of the Gift of the Givers, to come forward, please? Yes. Is he here? Angimboni behleli lapha ngasemva.
Yes. I'm giving orders here. No.
Mr. Solomon?
Space, I'm giving orders here.
Yeah.
Angwe.
Just say you want to acknowledge him for his role in humanity throughout the world.
All right. All right. Thank you. Ladies and gentlemen, ours is very easy. We've been asked to present gifts to the guest speakers as a sign of our appreciation for the time that they have spent with us and for participating in this magnificent event. We say on behalf of eThekwini Municipality, Advocates for Transformation, BLA, and the KZN Bar, siyabulela, siyabonga. Thank you. Last but not least, we also want to acknowledge Mr. Suleiman for the work that you've been doing in uplifting humanity all over the world. Thank you, Mr. Suleiman, for spending time with us. Look at the camera. Oh, yes.
Start again. Let's start again.
Okay.
That one or that one? Okay, what's the lady? You. Yeah.
Thank
you.
Oh, thank you very much. All right. Thank you, guys. Thank you.
Are there more photos of that?
or for the photo, and then we stand.
Are we taking a photo? For the photo? Together?
I think so.
Now they're going to appear in pictures. I started this thing.
Yes.
Like a horseshoe.
Together or two lights? Two lights.
Ladies and gentlemen, thank you very much. When you exit that door, there will be administrative staff. If you have got a parking ticket, you can go there and give it to them. They'll give you a parking ticket for you to get out of the parking. Now,